The boogeyman of affirmative action has struck once again. Find out how Edward Blum has been on a crusade to target all of the hard work that Black people have made, and the case that he successfully argued before a federal court to stop a Black venture capitalist firm from providing much needed resources to minority and women-owned businesses. Stay tuned right after this. For those of you all who have not been following, I did a video on this before, and I'm going to link that in the description box.
Hey everyone, I am attorney Augustus Corbett, one half of the Defiant Lawyers. Recently, I took a look at our analytics and I noticed something shocking. Many of you watch our videos and I believe you enjoy them, but you haven't subscribed yet. What are you waiting for? Again, I was shocked because I know our content is empowering and informative. Plus, our 2024 goal is to have 150,000 subscribers before the end of the year. Please help us by hitting that subscribe button, especially you young folks. We particularly want to increase our number of young subscribers. Thanks for all your continued support. We appreciate it very much.
A group called the Fearless Fund, which is a venture capitalist firm started by Black women out of Atlanta, offered much needed resources and money to Black-owned and minority-owned businesses. And they were sued by the same man, Edward Blum, who was behind getting affirmative action overturned just a couple years ago. And unfortunately, he has been successful in targeting all types of programs and initiatives that were put in place to benefit Black people. And so I want to talk about this case a little bit and just talk about the widespread consequences that this could have on private organizations that offer resources, money, support for Black people, and all of that. It really can spread, and we really need to be watchful about what could come from this. You all should be very alarmed about the development of this case. So just to give you all a little backstory on what I'm talking about, I'm reading an article from CNBC. It says venture capital fund, Fearless Fund, cannot resume making grants to Black women-owned businesses, a ruling that was put in place by a divided U.S. appeals court, siding with an anti-affirmative action group that sued over the program. The Atlanta-based 11th U.S. Circuit Court of Appeals, that's a federal court, found that the group's discrimination lawsuit was likely to succeed and reversed a lower judge's decision that the program should be allowed to continue while the case moves forward. Obviously, this ruling is a victory for Edward Blum, the conservative, anti-Black, in my words, activist behind the successful U.S. Supreme Court challenge to race-conscious college admission policies. Blum's group, American Alliance for Equal Rights, last year alleged that Fearless Fund was violating a 19th century federal law that bars racial bias in private contract. What this means is that this conservative federal court ruled that allowing Fearless Funds to offer $20,000 in grant and awards to be issued under the fund's Fearless Strivers grant contest would be, quote, substantially likely to violate a federal statute prohibiting racial discrimination in contracts. This is absolutely crazy, you all. As some of you all may know, we practice civil rights law. We sue corporations for racial discrimination against our clients under Section 1981 of the Civil Rights Act. One of them was put in place after slavery ended and then written into law by Congress back in the mid-1960s. And really what it says is that a corporation cannot discriminate against a person in their right to make a contract with that business, enforce a contract. So what does that look like? If you go to a restaurant and a restaurant refuses to serve you, you can potentially sue under 1981. Or if you go to a bank and the bank does not honor the contract that you have as an account holder with that bank because of the basis of your race, you can sue under this statute. If you go to a movie theater or any other type of corporation or business and you believe that you were discriminated against on the basis of your race, with the ability to make a contract with this company, to enforce a contract with this company, that statute gives us a cause of action to file a lawsuit against that person. But it's been so watered down by federal judges, conservative federal judges, who have made it extremely hard to prove discrimination on the basis of race. The standard is so very high, even though this type of law was put into place after the end of slavery in order to protect Black citizens who were formerly enslaved. So this law was put in place to protect us. And yet you have a conservative federal court who's saying that a Black-owned business giving grants to minority and Black-owned business owners violates Section 1981 of the Civil Rights Act. And yet, all these years later, you have this court and this man, Edward Blum, going through on a step-by-step basis and dismantling all of the protections that have been put into place to protect us. It is absolutely insane. And this can have widespread consequences for other organizations that target or are developed to help Black organizations, Black people, etc. So what did the Lawyers for Fearless Fund have to say in regards to this crazy ruling? Alfonso David, Fearless Fund's lawyer and the president of the Global Black Economic Forum, said, quote, "As the dissenting judge pointed out, the discrimination in access to funding that Fearless Foundation seeks to address is longstanding and irrefutable. This is the first court decision in the 150-plus year history of the post-Civil War civil rights law that has halted private charitable support for any racial or ethnic group." And Arian Simone, CEO of Fearless Fund, wrote, quote, "America is supposed to be a nation where one has the freedom to achieve, the freedom to earn, and the freedom to prosper. Yet, when we have attempted to level the playing field for underrepresented groups, our freedoms are stifled." That's just it. A program of money put in place to help even the playing field, which was the goal and the intent of this civil rights law, is now being used against us. This is the craziness that we are in today, you all. And this is why our vote matters. This is why voting matters. Because these judges were appointed by Trump when he was president, and they have these lifetime appointments that will really have a detrimental effect on us and on the Black community for the foreseeable future. So what happens now? This was a court decision by a federal appeals court. Really, the only option that Fearless Fund has is to try to appeal this up to the Supreme Court. But what you all may not know is that the Supreme Court only hears a handful of cases. There are thousands upon thousands of cases that matriculate through the federal court system, whether it be a lower federal district court, a federal court of appeals. And for the most part, the cases stop at the federal court of appeals, and then it becomes law. So the only way that this could potentially change and not have the negative reverberating effects that it could potentially have is if the Supreme Court decides to take this case up. But we know that with a 6-3 conservative Trump majority Supreme Court that have made all sorts of decisions, one of which was in favor of the plaintiff in this case to end affirmative action, it's highly unlikely that the Supreme Court is going to take this case up. So if that happens, this really does become the law of the land and can begin to affect other organizations and other businesses that seek to help with equity, help against racism and discrimination against Black people. And let's look at these numbers that Fearless Fund was trying to improve. According to a Guardian article, less than 1% of venture capital funding goes to Black and Hispanic women. Less than 1%. Not less than 10%, less than 1%. Digital Undivided, a nonprofit advocacy organization, found that firms started by Black women received only 0.0006% of venture capital funding raised by startups between 2009 and 2017. And in 2019, a report found that, quote, Black entrepreneur loan requests are 3 times less likely to be approved than white entrepreneurs, end quote. That is what we're trying to address. And with this ruling, the Federal Court of Appeals said that Nah, you all trying to even this playing field and promote equality, nah, that won't work under Section 1981 of the Civil Rights Act of 1866. Okay? That won't work. That's what this court has said. That won't work. Even though y'all get less than 1% of the venture capital funding to start your businesses, and there is a group out here that are trying to redress that, oh, you can't do that because that's discriminating against white people or other races of people. What type of logic is that? This country is going back, guys. This is what they mean by make America great again. This country is erasing and eradicating and eroding the protections that so many African Americans and our allies have given their lives for, have been killed over. And it's just, this ruling can be so broad. It can touch HBCUs. It can touch our program, BARS program, that we started to help improve the reading levels of young black boys and provide resources for educational opportunities for young black kids. It can affect me being a part of the African American Lawyer Society of the State Bar of Texas. It can affect so many different things. And that is what they're slowly trying to do. So that's why we must be awake, eyes wide open, ready to vote, so that we can put politicians, legislators, and judges in place who care about rectifying the evil atrocity of slavery and white supremacy in this country. So that's all that I have for you all in this video. I hope that you got something from it. What are your concerns about this ruling against Fearless Fund? Where do you see this going in terms of what other organizations it could potentially affect? I can't wait to hear your thoughts. Thank you again for tuning in, and I will see you in our next video.